Welcome to the news channel. Today we have the case of Mattel Inc. v. MGA Entertainment Inc., which the name of the companies are the ones mentioned respectively. In the summary of the case, we have that in April of 2005, the maker of Bratz dolls, MGA, filed a lawsuit against Mattel, who had previously created Barbie dolls. In this lawsuit, MGA claimed that the line of My Scene Barbies had copied the size of the heads and bodies of the Bratz dolls. Mattel then filed a suit against MGA, stating that this latter had infringed their copyrights by the production of Bratz dolls due to the fact that their creator, Carter Bryant, the designer of the Bratz, designed the doll while he was working for Mattel during the years of 1999 to 2000. Under a contract that established that all his designs and creations were the property of Mattel. Then, in 2008, a jury ruled in favor of Mattel, forcing MGA to remove Bratz on the shelves for almost a whole year, as well as to pay Mattel $10 million. Nevertheless, the Ninth Circuit of the Supreme Court of Justice considered that since MGA significantly improved the value of the Bratz dolls, since their investment of the toys, it would be unfair to revoke the ownership of the dolls even if the brand of said toys was not an appropriately created idea. Due to this, when reversing the decision, the Ninth Court realized that there was ambiguity in the terms of the contract under which Bryant was working for Mattel, because although it was stated that all his inventions would belong to the company, the term invention was not specifically described, and as a result, the district court reached the conclusion that the conception of the idea of the Bratz dolls were just merely inspirations that only exist in the mind, which are different from tangible inventions. So, finally, under the Copyright Act, the district court granted attorneys' fees and costs to MGA. Now to you, Mariana. You're at the Supreme Court. What can you tell us about this?
Thank you, Dana. Now from the courthouse, we are finally having a decision. First of all, the legal issue involved in this particular case is copyright infringement and trade secrets. MGA Entertainment allegedly infringed Mattel's copyright by producing Bratz dolls, as you said, but Mattel claimed that the designer of Bratz dolls was working for them at the time he came up with the idea. So Mattel and MGA were again in a fight for this copyright of the Bratz or of the Barbies, and finally Mattel sued MGA for this infringement, but later on MGA filed a counterclaim that stated Mattel has misappropriated their trade secrets. Okay, so the ruling of the court was that Mattel had to pay MGA $309 million for damages, which included MGA's court fees. At the beginning, the jury awarded $85 million to MGA, and then the court decided to give them an additional amount of $85 million. And finally, MGA legal fees, which consisted of $137 million. Adding all up, it is about $309 million. So the reasoning of the court was that Mattel's original claim was not valid because of the designer's contract. Although it was stipulated that all inventions belonged to Mattel, the pure ideas of the designer were not contemplated. So the court decided MGA should keep the ownership of the brand and pay to MGA all the court fees and, of course, the damages. Then back to you, Dana.
Thank you, Mariana, for your excellent report from the courthouse. Well, this has been the case of today, and we hope that you will keep on synchronizing us. If you have any doubts, please don't hesitate on letting us know, and until next time, thank you.